Thank you for joining us, everyone. Welcome to this press conference to discuss the judgment that was handed down yesterday by the North Gauteng High Court in the Social Relief of Distress Grant court case. So the judgment found that the various procedural barriers that were named in the case, as well as the rolling back of the grant in terms of its purchasing power, as well as the number of people eligible, they found that to be unlawful and what will surely be seen by many as a victory for fairness, dignity, and constitutional rights. So welcome and thank you to everyone for joining us in person here at the IEJ offices in Braamfontein, as well as online on Zoom. And also, of course, welcome to the panel who will be helping us unpack this judgment today. So on the panel, we have to my right, Gillard Isaacs, Executive Director, Institute for Economic Justice, who are, of course, the co-applicants in this case, along with hashtag Pay the Grants. Joined here representing them is Elizabeth Reiters, Deputy Chairperson for hashtag Pay the Grants. And then online, we are joined by Nomzamo Zondo, Executive Director for the Socio-Economic Rights Institute, SERI, who were the legal representatives for the IEJ and Pay the Grants in this case. So we'll start with by going to Gillard, who's going to help us by summarizing this judgment, as well as if you could give us the what you think this means for the economy, as well as politically, just economically and politically, what you think this means, as well as the IEJ's view on this judgment. Over to you.
Excellent. Thanks very much, Lucianda. I'm assuming I'm audible online. So I want to start off by explaining why we regard this as a historic judgment. Firstly, is its scope. The judgment impacts in a direct way the 18.3 million estimated people that are eligible to receive this grant. The last available figures show that only 7.5 million people were actually paid in the last available month of information, but there's a generally accepted consensus that up to 18.3 million persons fall below the food poverty line and should be eligible for the SRD grant. This judgment paves the way to make it easier for those who are accessing it now to continue to access, and to make it possible for the other 11 million to have access to this lifeline. It also handles issues of the arbitrary non-payment of this grant, and as we've heard, the unduly low levels. It's also a very important judgment because it asserts a constitutional imperative of ensuring the progressive realization and access to social security. My first task is to provide a bit of a summary of the judgment, and that's obviously available to everyone online. The first 30-odd pages deal with preliminaries and the summarizing of both the applicants and the respondents' case. The judge then goes on to make what we're going to share as 9 crucial findings in the case, after which he makes a far-reaching order related to the regulations which we're challenging. And to remind everyone, a case challenges the regulations associated with the SRD grant. So the SRD grant is established in terms of the Social Assistance Act, but the mechanisms for its implementation are put forward through a series of regulations which have evolved over time. And the court a challenge is mainly but not exclusively targeted at those regulations. So the first finding which the judge makes is that the SRD grant is not temporary. Whilst it might provide temporary relief for the individual who has no other means of support, the grant itself is not temporary. And this is important because the state grounded their case on an argument that the SRD grant was different to all other grants, that other grants were of a permanent character and the SRD grant was of a temporary one, and that justified the various ways in which procedures deviated from the norms. It also has left beneficiaries in a state of uncertainty and anxiety. And a judge makes a crystal clear that he does not view it as temporary. In fact, it is permanent in the same way as other grants are. The second is that a judge says that whilst procedural safeguards are legitimate in principle, for instance, to prevent fraud and abuse, these cannot be designed with the ulterior motive of limiting the number of people who should access the grant. And a judge notes in a number of instances that the regulations which are in place exist to unfairly limit access to the SRD grant, and that this is unlawful. Third, and now getting into the practicalities of the issues which we challenged, a judge finds that allowing online-only applications and not providing for the ability to apply for the SRD in person at SASSA offices is irrational and therefore unlawful. We argued that by allowing only online applications, you stand to exclude a large a portion of the poorest of South Africans, as like, for instance, about a fifth of the population does not have internet access. A judge then ordered that the regulations must be amended to allow for in-person applications at the SASSA office. Fourth, a judge made a ruling about how the term insufficient means must be defined. This is important because the SRD grant is available only to those earning below a certain threshold who are adjudged to have insufficient means to support themselves. Unfortunately, the current practice assumes any and all income to fall, or almost all, to fall under the understanding of insufficient means. And what that results in is that the applicants who, say, receive support from a family member because they are unable to feed themselves, or unable to access the SRD grant itself, might be found to be ineligible because that income comes through their bank account. And the court found that you need to define income and financial support in clearer and more narrow terms to refer to money to which the recipient has a legal entitlement to receive, and provides for a clear and concise definition of income and financial support, which will mean that the receipt of other income or shared income will not unfairly exclude an applicant. Number 5 is that a court found that the government's utilization of out of date and faulty databases to assess whether an applicant was eligible was unfair and was therefore unlawful. The government has been using the UIF, NSFAS, SARS, and other databases as a means of assessing whether someone has work and income. Those databases, it is widely accepted, are out of date and faulty, and the government has tried to shift the responsibility for seeing those to be updated onto the individual. And the judge is scathing in this regard, saying that it is incomprehensible why the respondents, the government, would continue to make use of such databases. The judge then declared this part of the regulations to be unconstitutional and invalid. Similarly, the state makes use of a bank verification process. This is number 6 in the findings, whereby it is one's bank account is reviewed to see the money which has flowed through that, and if the amount of funds surpasses that of the means threshold, you may be deemed ineligible. What these bank verification mechanisms fails to do, though, is to distinguish between any form of a payment, of a child maintenance support or a gift, to distinguish those from income earned through work. And once again, the court found that the use of these was, and I quote, irrational, arbitrary, and that it's unfathomable why government would do so. And in this respect, ordered that that part of the regulations are invalid. Number 7 is that the judge ordered that the access to the grant can't be limited through an through a budget cap that is arbitrarily imposed. Excuse me there. What National Treasury has imposed is to say this is a budget now at 33 odd billion. If there are more successful applicants than we have money for, the last applicant in line after the funds runs out simply won't receive the grant, even if they are otherwise eligible. This has been deemed to be invalid and unconstitutional. And once again, that part of the regulation was struck down. Interestingly, a judge notes and is critical of a budgeting process which budgets less funds than what is necessary for all eligible or for the entire pool of targeted individuals. And whilst deferring to the executive's right and authority in budgeting is refers to such a decision as being completely incomprehensible and irrational. Number 8 is that a court finds that the government must put in place a plan to see the progressive increase in both the value of the grant itself and the means test threshold. As we know, for the first years, that grant stagnated at the value of 350, only to be increased last year to 370. But even with that increase, the value in real terms in its purchasing power has fallen. And that equates to a retrogression in access or in the benefit derived therefrom. Similarly, the means test threshold, which was originally set at which was set in these regulations at 624, the food poverty line at that time has been left at the same level, despite the fact that the food poverty line has increased to 796. So a judge finds this to be in breach of the constitutional requirement to progressively realize the right, and orders that the government put in place a plan within 4 months to rectify this. Lastly, the 9th finding is that SASSA must investigate and put in place a plan to rectify the non-payment of successful applications. So what we've seen is that about 10 to 15% of approved beneficiaries have not received their payment despite them being approved. Once again, the court is quite scathing about this and orders that a plan is put in place to see it rectified. I know I've utilized a lot of your time, so I want to just make 2 last closing sets of observations. The first is that in addition to these 9 really important factual findings and orders, the judgment vindicates the activism and work of civil society or organizations and its criticisms of government. A judge notes that, as we have argued repeatedly, the unlawful exclusion of eligible beneficiaries is not a quirk of these regulations or a distortion or a mistake. It is the purpose for which these regulations are actually being made. That government is, through these regulations, purposefully excluding eligible recipients in the name of limiting a budget expenditure. And the judge agrees with us there, and on a number of instances notes that these regulations are intended to exclude. Secondly, he rebukes the Minister of Finance in at least 2 instances for overreach. Overreach both in National Treasury imposing, if not the exact substance, the need and tenor of these exclusionary regulations in order to limit expenditure, and overreach in the conduct of the a court case itself, where National Treasury led, despite this not being an area for which they have direct oversight. And what this highlights is the inequities within government and the undue and unwarranted power being influenced by those in a government who hold the purse of strings. And that undue influence is once again being exercised right now with National Treasury once again allegedly attempting to not renew the SRD in the upcoming budget. A judge is also scathing of the, and I quote, what he sees as the indifference to the human suffering caused by this. Very lastly, we as IEJ and as partners, we are obviously thrilled by this judgment. We call on the government to respect it, to see to its implementation, to not drag this out with unnecessary appeals whilst many millions suffer, even if that is their legal right. And that this judgment is not a judgment to the benefit of us as applicants. It is a judgment which assists government in actually implementing their own stated policies more effectively. And if allowed to be fully implemented immediately, would ensure the improvement of South Africa's social security system. Thank you.
Thank you, Gilad. Now, Elizabeth, I know that you work with applicants and beneficiaries on the ground every day as part of Pay the Grants. So what would you say has been the experiences of them the beneficiaries and applicants in terms of like navigating the very difficult procedural barriers that were challenged in this court case. And what do you think this landmark judgment will mean for the lives of those applicants and beneficiaries? Or as well as you can also give us the overall views of Pay the Grants and their reaction to this.
Good afternoon to everyone. My name is Elizabeth Reiters, and I am the deputy chairperson of Pay the Grants. Sianda, I can assure you, since the SRD has been introduced, it has been a struggle for beneficiaries. I can tell you the regulations that SASSA has been setting up has actually made it so difficult for deserving beneficiaries to actually access the 350, which is now 370. Yet these beneficiaries are not actually even receiving the 20 Rand because it goes for bank charges. Because you have to upload bank details when you apply for the SRD grant. As you all are aware, that they did take away the option of retailers of Postbank. So that's no more on the website. So you're obligated to open a bank account. And every month you have to pay monthly fees for a bank account. When you withdraw the money, you have to pay withdrawal fees. So that 20 Rand is actually not for the beneficiary. Actually, they've been making the banks rich and not the beneficiaries. So there's really no difference in it. I must tell you, it's also been a struggle for beneficiaries who have been unfairly excluded. Like Gilead was saying earlier on, I have certain beneficiaries that would maybe receive their CSG in the SASSA Gold Card, and they have to maybe pay the child's school transport. So they will withdraw the money and then put the money into their bank accounts so that they can transfer it to the school transport. But because they're doing that, they will get declined. So they are actually getting declined for SASSA's own money. So I am happy with the judgment that the judge actually gave. And I just hope SASSA actually works on this and actually implements it and not really take it to appeals court, because I have spoken to SASSA on previous occasions and I've told them that we work on the ground on a daily basis. So you see how beneficiaries are actually struggling. You see how they depend on this grant. Some of the beneficiaries, this is the only income they have. And as you know, with food prices being so expensive, 370 is actually nowadays just for 2 days. So you can't even buy the basic necessities with the 370 Rand. So, but I think beneficiaries are very, very happy with this judgment, which means more deserving beneficiaries will actually finally access the grant, which they're supposed to get because it's your constitutional right if you can't take care of yourself, for the government to take care of you. And with the unemployment rates, it's so high. So it's not like even the government is creating any jobs. So I really do think this is in favor of beneficiaries, and I really do pray SASSA implements this as soon as possible. Thank you.
And thank you, Elizabeth, for giving us those perspectives. We now go to the last panelist, Nomza Mozondo from SERI. Could you please give us what SERI's reaction is to the judgment, as well as if you'd be able to situate the judgment or what it means for socio-economic rights and the Constitution?
Thank you so much, Sianda. Look, firstly, at SERI, we celebrate alongside Pay the Grants and the Institute for Economic Justice for the scope for government to remedy this injustice. And we really also celebrate the fact that the court was quite articulate on the callousness of the state, repeating every now and again. So you can't actually take steps to reduce the ability of deserving beneficiaries to receive the protection that the Constitution provides to them. And really, the fact that at some point the governor is saying this is the reality of the situation, for the court to have come out and confirmed what is actually long-standing law, that as the government, you have an obligation to budget for your obligations. You cannot actually budget yourself out of your obligations. Something. It means if there are 18.3 million people in South Africa who are not able to support themselves, then it is up to the government and actually the fiscus to provide protection and provide support for those beneficiaries. The fact that we've had the court quite clearly, I mean, I feel the judgment is lovely to read. It's easy to read. Any of the beneficiaries can read it as well. Just how the court clearly sets out why every step, every point that the beneficiaries complained about the regulations was unfair. How even on how it cannot make sense to say the poorest of the poor, who are unlikely to have no means, must go and apply online. How it really must be arbitrary to have taken that step. So I think as SERI, just to clearly say, we welcome the judgment. We also want to appreciate the beneficiaries and pay the grants which organizes them, which took the step to challenge government on this, and appreciate the support from IEJ, having been able to bring both the institutional knowledge of the IEJ, the needs of the beneficiaries before the court in a way that kind of said, we should not even have been here. I think when I finished reading the judgment yesterday, I really wondered, why was so much money spent on litigation on this point?
Nomzamo, can you hear us? You can see the picture moving again. Can you hear us? We can't hear you.
It was coming through fine earlier. It broke up very briefly, but we were hearing you. Unless you want to turn your camera off and then just speak that way.
Sure, thank you, Gillard. Sianda, are you able to hear me now?
Yes, we can hear you now.
Sure. The challenge is I don't know where you lost me.
You were talking about the how much money was spent on litigation. I didn't understand how much money was spent on litigation from there.
Oh, okay. No, I think that was really my final point, Sianda, which I felt that of course, having been part of this very long and complex litigation, I think we would understand as legal representatives. But when you read the judgment outside of that, you see how it should have been unnecessary for the beneficiaries and IEJ to litigate this case. That it should have been it should have been clear to the state actors that something has gone wrong in their budgeting, in the regulations. And if it wasn't clear before food off the table of one more poor person, which is what the judgment reads as in the final analysis.
Thank you, Nomzamo. We'll now open the floor for questions. So how we can do it is we can take a round of questions and then allow the panelists to answer. And then if there are more questions, we'll continue the process in that way. Dali, if you could let us know if there are any questions online. Okay.
Or you allow people to speak.
I'll see. So they're welcome to post it both in the chat box or to raise their hands.
Any questions?
Before I ask my question, I just want to know, will you be able to do one-on-ones after this? Okay. Maybe can I just get clarity? Also, just for my request, just can I have the names and the surnames again of everyone at the top table, but maybe just a clarity on says that's 10 to 15% of applicants as is are not getting paid. Is this the SRD grant specifically that you're referring to? And maybe you can just talk to us about why that's happening. What are the issues around that? Yeah, and maybe just a question on the financing of this. There's always a lot of questions concerned from the public even about who funds the social welfare, and if there will possibly be more people that will now be added to the list. Just your thoughts on the funding and how that can be achieved. Sorry, and I'm putting TP from ENCA, sorry.
Yes. I think you can answer that question so long while everyone else still formulates. Just very quickly, just in terms of the name, so it's, to my right is Gillard Isaacs, Executive Director, Institute for Economic Justice. Okay, I'm Sianda Baduza, Institute for Economic Justice as well. Next to me is Elizabeth Reiters, hashtag Pay the Grants Deputy Chairperson. And online is Nomzamo Zondo, SERI Executive Director. And I'll allow Gillard to answer.
So that number is with reference to the SRD grant in particular. Non-payment of approved beneficiaries, as far as we understand, is not as huge an issue for any other grant, although I stand to be corrected there. In terms of why, government has at different moments put forward different answers to do with verifying bank accounts, verifying your identity, verifying your cell number, various things. But and the judge notes in paragraph 154, the respondents, meaning government, offered no defense for the non-payment of SRD grants to successful applicants, except to say that the system experienced some teething problems and that some successful applicants failed to furnish their correct banking information and cell phone numbers. So what a judge is noting there is what any observer in the court would have noted, which is that both in the papers and orally, the explanations for this number, which runs into the hundreds of thousands, was garbled, incomprehensible, absent, contradictory at times. So it's not clear to us to be able to say of these applicants, X amount are not being paid for X reason, Y reason. That information at the level of clarity, which the court would expect, was not adequately furnished. In terms of the implications of this, there is no doubt that this has budgetary implications, right? By the government's own estimates, up to 18.3 million individuals you know, are the ones who fall in the eligible pool, right? Which is double or more what is currently the number accessing it. So I think there's two different questions here. There's a legal question and there's a budgetary question. The legal question, a judge makes clear by saying, if you design a policy that is targeted at a particular group, and that group equals 18 million, you can't then go and put in place barriers so that only half or under half access it. That's unlawful, right? And that's what's been happening, right? And so a judge is clear that he's not stepping into the realm of, you know, saying move money from here to there and so on. At the same time, there is a budgetary question, which obviously shows that if a larger group is to access this, then more funds will need to be allocated. The IEJ has put forward over the last 3 or 4 years, on more than one occasion, a financing plans for the rollout of basic income, which could easily be used in this instance. So, including income through a social security tax, a wealth tax, reallocations within the budget, limiting corrupt and wasteful expenditure, and so on. The last thing I'll just say on that, because you know this is sort of a much broader kind of conversation, is that it's important to distinguish between the gross costs and the net costs. So what I mean by that is the costs on paper, but the fact is that government would receive a certain portion of that back in VAT through expenditure, and it would see a economic benefit through increased spending, which also is likely to result in increased revenue. So, you know, this is a meaningful amount, but it's by no means an extraordinary large share of government's budget. And there are certainly ways in which budgeting can occur to ensure that the unlawfulness is neither necessary nor ongoing. I don't know if other colleagues want to add.
Yeah. Is there any other question you'd like to know?
Any questions online? Any more questions in the room?
More of a forward-looking question. So this obviously isn't on paper directly, but can be definitely read from the kind of modeling around the idea of a job seekers grant, especially the change in the language and the discourse from Treasury and even in the last SONA. As is obviously the last medium-term budget policy speech statement put out that there is no funding for the SRD going forward, implicitly suggesting it's supposed to be cancelled or giving that choice at least to the president. And we have that against the backdrop of knowing that they price the idea of a job seekers grant as a much more efficient option, even though it's something that falls apart very quickly as soon as you ask, how does this actually work? How do you think that this legal judgment actually kind of affects the political context? There's nothing in this ruling that says you have to continue the grant, obviously. So what are the thoughts around, I guess, the political landscape at the moment?
I don't know if the other two want to answer that first.
Nomzamo, Elizabeth, would you like to?
Okay, I definitely do think Treasury has no right to say which grant beneficiaries will get. I do feel grants belong under the Department of Social Development. It's their portfolio. And I do agree with the judge on that Treasury is overstepping because them calling another grant, they're not responsible for grants. Grants belong to the Department of Social Development. It's their portfolio. So I don't understand why Treasury want to suggest the job seekers grant, especially with no jobs available. So how is that actually going to work? I really don't think it will be able to work out in this country.
Thank you, Elizabeth. Nomzamo, do you have anything to add to that, Gilad?
No, I feel that Elizabeth has captured it well. The decision has been made on the SRD. I think the finding from the court that it's a permanent grant also kind of gives us clarity moving forward. I think Treasury, their role is to budget. They must continue to do that. But at this point, we need to respect the vision put forward by the Constitution and basically the attempt to protect the poorest of the poor in our country through the SRD.
So the final sort of thoughts then, and you know, I think we are in dangerous and murky waters. As I said in my initial input, we have been made aware that National Treasury in the run-up to this year's budget is once again attempting to see the SRD cut and removed entirely. As Nathan said in his question, there was some ambiguity in the medium-term expenditure framework of the MTBPS, where we argued that and other observers that no provisions were made for the SRD, whereas National Treasury and the Minister of Finance sort of semi-formally and through the Cabinet Secretary said that, you know, that it is there in a contingency and will be allocated and so on. So there was some confusion in the wake of the medium-term budget policy statement last year. You know, so we are once, and this grant has persistently faced a chop, as have numerous other really important programs like the presidential employment stimulus and others. This judgment can play into that political waters in different ways. Okay, it can play into that political waters in a way which might make National Treasury even more robust in arguing that it's unaffordable, because they might now say, well, not only do we need to offer it to 7.5, but this judgment means we must offer it to even more, and therefore it's even more unaffordable. And that, of course, is not what we want to allow for, but it may be a kind of a devious way of using this judgment. What the judgment should articulate is the legitimacy and necessity. You know, this is, you know, a judge does not say this in explicit terms, and no doubt sees his role in circumscribed manner, but implicitly a judgment solidifies the legitimacy of social security for those who do not have access to other forms of support, which provides, which haven't been catered for in the existing system so far of the other grants. And so we hope that the President, the Minister of Social Development and others will use this judgment to strengthen the social security system. If we're wrapping up, Chair, I wanted to just, we had one more question.
Hello, my name is Delene. I would just like to know, if Treasury takes away the 370 grand, and there are still people that must get debt paid, how is that people going to get their debt paid from SASSA? Get SASSA only. What will they do?
I think that's a question which we would need to pose to those in policy making, because I think it poses a withdrawal of the grant, poses a range of technical, legal, and moral questions, and that's certainly one of them. I don't know what means they may put in place. I just wanted to see, and I don't know if we're wrapping up, but I wanted to, using the mics in front of me, the opportunity to thank a few people that were involved in this case. This case is not anywhere near over. I mean, we hope that it might be, and that a government decides to abide by this ruling. Even if that is so, there's still a role for the High Court, because it's ordered that government develop various plans which are then tabled in court. So even without an appeal, the legal process isn't over, but it may also go on appeal. But at this stage, I wanted to just thank from IEJ side our co-applicants. Pay the grants was instrumental in this case and in securing the 79 affidavits from individuals that have been impacted by these exclusionary measures, and has been a voice on this issue consistently for the last 4 years. Our lawyers, SERI, the Socio-Economic Rights Institute, which has been a champion for the most vulnerable in South Africa for a decade, and worked tirelessly to ensure that the court case move forward. And our counsel team, Jason, Michaela, and Michael, who represented us so ably in preparing for this and in court. And of course, all of those within IEJ, led by Neil, Coleman, Kelly, Houseland, and Sianda, in undertaking this work. So a huge thanks from IEJ to our partners in this, and we hope to be able to work hand in hand moving forward.
Right. Thank you, Gilad. I was going to give the panelists just a moment to just say any final thoughts that they have. So, Elizabeth, anything you'd like to say in closing?
Oh, yes, I would really like to thank our partners in the UB. They've been really being supportive in our fight against the government during this court case. I would really like to thank IEJ. We couldn't have chosen a better partner to team up with. And I would really like to thank SERI as well. SERI did a brilliant job in actually presenting the evidence directly from the beneficiaries. I can actually remember when we went to go sign these affidavits in 2023, it was like the coldest night of the year. And myself and the Commissioner of Oaths was like going door to door signing these affidavits. But we got the evidence done. So I also would like to think government must really just improve the SRD system, because at the end of the day, the SRD is the baby step to the UPIC, because it is time for UPIC now. I really do think it's time for UPIC, and government should really just look at the poor and come out behind the tables a little bit. Come to the ground, come walk around, look at it. See how beneficiaries are living, how they're surviving, listen to their stories, and then hopefully they would understand what we're understanding. Thank you, everyone.
Thank you, Elizabeth. Nomzamo, do you have any final words from SERI's side?
No, I think it would just be to encourage government, especially those that are in leadership, both social development and the treasury, to take up the opportunity to do the investigations that they've been ordered to do by the court, to work with beneficiaries and even our clients, IEJ, and pay the grants, to actually complete those investigations and find a better way to make sure that this SRD grant reaches everyone that deserves it. Thank you so much.
Okay, thank you. Thank you to the panel, and thank you to everyone for joining us online and in person. Thank you and have a good afternoon.
Thank you.
On an administrative note, a statement by the three organizations is now available and will be shared on our WhatsApp groups as well as in the Zoom chat and through our mailing lists. Thanks, everyone.
Thank you.